joining our webinar today. My name is Jessie Peterson. I'm the Director of Education here at SunRay Construction Solutions. SunRay secures $10 billion annually for GCs, subs, and suppliers. We're a national construction document service. Today's webinar is conducted by the wonderful Adam Jarvis, an Alabama construction lien law expert. Today's webinar topic is Lien and Bond Claim Masterclass, everything they don't tell you, but should. So without further ado, I'd like to introduce the fabulous Adam Jarvis.
Hi, my name is Adam Jarvis. I have a law office in Mobile, Alabama, and I have been collecting delinquent construction debt for about 12 years. My father owned a plumbing company and encouraged me to go to law school so that I could collect his bills that had not been paid on time. And even though that plumbing company is not around, that seems to be a major part of my law practice and probably always will be. So I'm happy to share some of the things that we do here at the law office every day, and maybe can help you in your process of collecting your debts. If you have any questions, let's see, there's a chat box to the right that you can enter questions in. And I'll be happy to take time to answer those questions if I have answers to them at the end. But no need to be specific about your own name or your company's names. Just ask those questions in a general manner, and we'll answer them in a general manner as well. You know, some of the things that we'll talk about today, your contract, and some of the things I'd encourage you to have in a written contract. Then we'll talk about securing your lien rights, talk about securing bond rights, some of the state of Alabama lien and bond rules and exceptions to those rules, some things to avoid with respect to lien law in Alabama, and the right way to exchange a release for a check. And then Jesse can talk about SunRay a little bit at the end and some of the things that they can do for you. So with respect to your contract, you know, first of all, I'd like to encourage everybody to have a contract. I have a lot of clients, particularly in the trades, that will provide written estimates to their customers and then accept acceptance of those estimates, from which they'll move forward with the construction based on an acceptance over the telephone. And you really don't want to do that for a couple of reasons. The Alabama Prompt Pay Act requires a written contract for you to recover reasonable attorney's fees and statutory interest. And that interest rate, I think if I remember, is about 7.5%. That can add up pretty quickly to a pretty good amount of money. And you really don't want to miss out on those rights that are provided to you through the Alabama Prompt Pay Act. And so if you are using an estimate and asking them to sign the bottom, I'd really strongly encourage you to add some language that says that upon signing and accepting this estimate, this becomes a binding contract, so that if we're in a courtroom, you know, litigating over collecting on that on the invoice related to that work, we can show the judge that, in fact, the thing that the owner signed said that it was a binding contract, so there won't be any question. You want your contract, of course, to be in writing, just for the reasons that we just talked about. It needs to identify your company or you and the owner of the property, and identify the property itself. The more specific you can be about the scope of work, the better. I have a lot of trades that have a general scope of work, and when they're, you know, 3/4 of the way through, we're constantly having an owner say, well, I thought you were going to also do this, and I thought you were going to also do that. It's so much better when you can look at the scope of work and point out in it that no, it was specific about what we were going to do, and those other things that you're asking about are not in that scope of work. Those will require a change order. Of course, to have a contract, you need a price, and of course, a signed acceptance by an owner, just like we talked about a second ago. With respect to home builders, I put in there that Alabama home builders are required to use a valid written contract, including an offer and acceptance signed by all the parties. And that's usually not a problem. I think everybody knows that if you're a home builder. But a lot of the times that my home builder clients need me is when we're fighting over change orders after the work has been done and we're trying to get paid for those change orders. And so I just really encourage everybody to make sure that your change orders are in writing. Don't do them in text messages. Have a proper change order form signed by both parties. If it's new construction or if the renovation is being financed by a bank, I encourage the bank to be aware of that. Some of the problems that we run into are when the change order is outside of the budget that the owners were approved for when they got the construction loan. And so it's better if everybody is on the same page. And really, I think a best practice, even though it's hard to do in the real world, is that change orders be paid before the change is performed by the contractor. Not everybody can do that, and I know you're trying to keep customers that you're happy with you and maintain that relationship, but there's a lot of risk on your end when those change orders don't get paid, particularly when they were outside of the original construction budget. And then down at the bottom, just like we talked about, if you're using estimates, accepting instead of a traditional contract that says it's a contract, you'll want to make sure that there's language where they sign the acceptance that says this is a contract when you sign it. Moving on to talking about securing your lien rights. In order to have lien rights, you need to complete the project, and you need to do so in a manner that's free from defects, in a good and workmanlike manner. One of the real keys to lien rights is the statute of limitations, especially if you're a subcontractor. Boy, do they come fast. If you are a subcontractor or a material supplier, before you record a lien, you need to give notice to the owner of the property. Usually at the same time, you'd copy that letter to your general contractor, and let them know that you have not been paid on an overdue bill and that you're intending to claim a lien. Usually in that notice to the owner, we'll put all the same information that would go in the lien itself, with regards to the property description and description of what the unpaid bill was for, in a general way. If you're a subcontractor, a materialman, or a laborer, you have what's called an unpaid balance lien. Your lien is only as valuable as the amount that the owner still owes the prime contractor who directly contracted with the owner. And so if the owners of the property have already paid the prime contractor in full, then your only recourse is against that prime contractor who's been paid the money that he or she owes to you. And so if there's a way to find out from the owner if there is an unpaid balance to the prime contractor, you'd want to find that out before you put a lien on the piece of property, and risk having recorded a lien that is illegitimate or unlawful. Some key dates to talk about when we're talking about statute of limitations. Prime contractors, those contractors that contract directly with the owner, must record their lien within 6 months of the last day work was done or materials were delivered to the site. Subcontractors must record their lien within that is a typographical error. It's 4 months. 4 months to the last day for subcontractors. Last day work was done or material was delivered to the site. So 6 months for prime contractors, 4 months for subcontractors. So you really want to mark that in your calendar, both the last day that you were on the project site and where that deadline is to record that lien. And then enforcing the lien once you filed it, which means filing suit, either in a district court or in a circuit court, usually in the county where the project was. You need to do that whether you're a prime contractor or a subcontractor. You enforce the lien within 6 months after the entire debt was due. And so notice the distinction in the statute. When you record the lien, you're looking at the last day that you did work on the project. When you're enforcing the suit, you're looking at 6 months after the entire debt was due. And so there may be that your invoice allows a 30-day grace period. It may be that your contract with the prime contractor had a pay when paid or a pay if paid clause that may actually give you more time than you thought in order to file that lawsuit. As a best practice, I still like to file suit to enforce the lien within 6 months of the last day that we were on the site, because it's just safer that way. But you may have more time, and that's something to think about with your own lawyer if you think you're getting close to that deadline. With respect to bond rights, it's funny. I have been a lawyer for 15 years, and I've been collecting construction debt since I've been in private practice for about 12. And for the first, I'd say 10 years of that, almost all that work was lien work. There were very few bond claims. I'd say the last 2 years, I almost have as many bond claims as I have liens that we're collecting at the moment. And I'm not sure if there's a good reason for that, but that seems to be how it's gone. Bond claims you can think about very similarly to lien claims. It's for public work on public land. You can't put a lien on public land. But in either case, you need to have finished the project and have done so free of defects in a good and workmanlike manner to have bond claim rights. There are a few differences. Lien rights are property right with the land where the project is located, conveyed by statute. Your bond rights are, contractual with a surety, an insurance company. And I've identified the statutes for each if you ever want to go look those up. What we really care about is most of the time the payment bond. When I typically represent subcontractors and material suppliers who want to get paid for public construction work that they've done. And the statute provides any person entering into a contract with an awarding authority in the state for prosecution of any public work before commencing the work shall execute a bond with the obligation that the contractor or contractors shall promptly make payment to all persons supplying labor, materials, supplies, for in the prosecution of the work provided in the contract and for the payment of reasonable attorney's fees incurred by successful claimants or plaintiffs in civil actions in the bond. And so, great news if you're a subcontractor and haven't been paid. Terrible news if you're a general contractor and they're threatening bond claims against you. But the bond claimant's got to give 40 to 45 days written notice of the bond claim before filing suit. And you must file suit not later than 1 year from the date of final payment by the owner. And that's usually a pretty big span of time. A lot of times, you may have a bond claim that arises about the time that you're finishing up work and may have a couple of payment applications that have not been paid. And the final payment by the owner may be maybe months after that when the 1 year time clock just starts ticking. I made a note there at the bottom that don't forget that successful claimants are to be awarded reasonable attorney's fees in addition to the amount of the claim if you file suit and win. Talking about some lien and bond rules and exceptions. Key with all of this is the statute of limitations, the time within which you've got to act, the notice requirements, if you are a subcontractor or a material supplier in the case of a lien, or for everybody in the case of a bond, and then what those documents need to include. Now here I've got the timelines correct, and so I apologize about the typo earlier, but you can see with an original contractor who contracts with the owner of the project, you have 6 months from the last day of work on the project. And for subcontractors, you have 4 months from the last day work was done or materials were supplied to record your lien. And in both cases, we file suit 6 months after the entire balance for that work is due. With respect to notice requirements, like we talked about before, if you have a direct contract with the owner, you can just record a lien when you have a delinquent bill. There's no actual requirement that you give that owner notice that you're going to do so. Maybe a good idea. Usually around here, we'll write a demand letter and let them know, hey, pay the bill in 14 days or we're going to record a lien. But that's not required by law. Whereas for subcontractors, material men, and laborers, you have to give notice to the owner of your intent to file a lien. I believe the statute doesn't say how much notice. We usually try to give them a week or two, but I don't think that's technically required. As long as they give them notice, and it should be sent by certified mail. Before you record the lien, you've met the notice requirement, to my knowledge. The notice needs to be in writing. It needs to be addressed to the owner, proprietor, or his agent of the property where you did the work. You notify them of the fact that you claim a lien on the land, building, and improvements. You let them know what amount of your lien is owed and for what. Just a general description, just a sentence of what you did it, whether that be for electrical, labor, materials, and supplies, or for roofing, labor, materials, and supplies. That's enough. Identify who owns the property, especially if you're writing to a property manager or an agent who's different from the owner themselves. And then we always send that notice by certified mail, and keeping a copy both of the notice, but also a copy of the envelopes with the postage on them, so that we can attach those as exhibits if we have to file suit. We'll make them exhibits to the complaint. With a lien amount, we talked a little bit before about unpaid balance liens. If you're a subcontractor or if you're a material supplier, then the amount of your lien is not necessarily the full amount of your invoice. If your unpaid invoices are greater than the amount that the owner still owes to the original contractor, who the owner is contracted with directly, your lien would be in the amount of the unpaid balance that the owner owes to that original contractor. An exception to that is if a material supplier can have a lien for the full price of unpaid materials without regard to whether the amount of the claim exceeds the unpaid balance to the contractor. If before furnishing any material, that material supplier gives notice to the owner of the property or his agent in writing, and specifying what material will be furnished, at what prices, and the owner does not object to it. And in fact, the Alabama legislature has adopted a form, which I have put here down as the example, that comes directly out of the statute, so that what the notice should look like if you're a material supplier, sending that notice to the owner of the property, is take notice that the undersigned is about to furnish the name of your general contractor, certain material for the construction or for repairing, altering, or beautifying of building or buildings or improvement of improvements, on the following described property, and put in a property description if you can. An address and a parcel number is good enough, but it's our practice that we'll do an address, a parcel number, and a legal description of the site where the materials will be delivered. And then there will become due to the undersigned on account thereof the price of said material, for the payment of which the undersigned will claim a lien. And then signed by, the credit manager or the owner of the material supplier. And with that notice sent before you deliver the materials, you material supplier can have a full lien for whatever the amount of your unpaid invoices are, without respect to worrying about whether or not the owners have paid the original contractor the money that is owed to you. With respect to bonds, like we talked about before, you have to give a 45-day notice to the surety, the prime contractor, and the owner by certified mail before you can file suit. If the subcontract has a pay if paid clause, you can't ask for retainage until the general contractor has received retainage. So you may have a few payouts that have not been paid in addition to the retainage, but the pay if paid clause in the state of Alabama, if they're clear and unambiguous, are typically enforced, and so you'll want to only ask for bond claims for the amounts of money that the owner has paid to the prime contractor, and that may be amended from time to time if you get notice that the prime contractors received additional payments. Because you're dealing with an insurance company, they're going to want to look at most of the documents in your construction file, but particularly when you file a bond claim, you'll want to include with that bond claim a copy of your subcontract, a copy of your payment applications, and I would recommend giving them all of the payment applications, both the ones that are paid and the ones that have not been paid, and distinguishing between the two. And then receipts for your own costs, out-of-pocket costs related to the project. They like to look at those as well. Discussing some lien law traps to avoid. Hey, don't file liens if you don't have lien rights. A lot of that, I have an appointment just this afternoon of a homeowner who had a contractor who did a whole lot of things wrong and then recorded a lien against the house. He doesn't have lien rights because the work was not completed. There are defects. A new contractor is going to have to be brought in to correct those defects, probably for more money than the original one is owed, who abandoned the job. And so before you file a lien, you'll want to think about, have you fully performed on the contract? Are there uncured defects in your work? And sometimes we're not talking about small punch list items. There's a difference between small punch list items and, not completing the scope of work in the original contract. I don't think that punch list items necessarily prevent you from being able to file a lien. But major items that are identified in the scope of work certainly would. Take a look at the statute of limitations, and are we still within time to record that lien? Make sure that you have the license to do the work. You don't have lien rights if you, let's say, did renovations on a house more than $10,000 and you don't have a home builder's license. Or if you did work on a construction project for more than, $50,000 and you don't have a license from the Alabama General Contractors Board. Or if you're a Tennessee general contractor and you decided to do a job in Birmingham, but you don't have an Alabama license. Well, you don't have lien rights in Alabama if you don't have an Alabama license. So it would be better for you not to record that lien, because you may wind up having to pay the owners and the general contractors' legal fees. Let's see. And also think about, make sure that you've given proper notice to the parties, whether if it's a lien or a bond, you should be sending a letter letting them know that you intend to file a lien or a bond claim to the owner, to the prime contractor, any other contractors that are up the chain of contracts from you. In your verified claim of lien document, you want to make sure you've identified the owners of the property, and then also identify the party who owes you the money and the addresses for each of them. And try to make sure you identify the correct piece of property to be liened. The statute says that a street address is enough. I think that the state of Alabama should really be more stringent and require at least a parcel number, if not a full legal description. It's not a problem when you're talking about a house in town that has been established in a neighborhood for a long time, but it is often more complicated if we're talking about a new subdivision, a new development, which, especially when the mailing addresses, somebody thinks that they know what the mailing addresses will be, but they're all brand new and haven't been set yet. It's easy to make mistakes, and better to use the full legal description. Let's see. All right, let's talk a little bit about the right way to exchange a release for a check. If you're in the same town, it's my practice. I like to do it in person. And so typically I have a lien release, and I don't record that lien release usually at all. I let the other party record the lien release, and I hand it to them at the same time that I receive a check. That's most typical. You know, when I've got a lien release from the client that's signed, I will give the other party a call and try to set up that meeting. If we're at a greater distance than that, usually we'll talk over the phone about when we'll have a check ready on the part of the owner or the general contractor, and typically when I'll have an executed lien release that's ready, and I'll scan the lien release, and usually also scan a copy of the envelope to make sure that they can check and see that the address is right, and ask them to do the same. To please send me a scan of the check and send me a scan of the envelope. Jesse, if you'd like to wrap it up, I think that's everything that I had to talk about today.
Wonderful. Well, first of all, thank you so much, Adam. You really are fantastic. So I do appreciate it. You gave us some really good information there. We do have a couple of questions that came through, so bear with me here. It says, and I believe you kind of touched on this, but it says, am I able to amend my lien, referencing the amount, etc., if I'm still within the deadline to file the lien?
Yes, amending the lien is not a problem. When you filed it the first time, you've given everybody notice about the lien that they can refer back to. And so, no, amending the lien should be no problem at all. Just note what original filing, whether that be by book and page number or instrument number, it relates to on the amendment. But yes, you can amend the lien, and that's a pretty common thing to do.
Okay, wonderful. Another question that came through, it says, on a commercial job, are there any lease provisions or lien prohibitions that can be recorded in the county by the property owner in the case that there is a leasee for the property, in which it prevents a lien from being placed on the real property? And if that's the case, can a lien be filed against the tenant's interest on the property?
I think that that's probably a question worth sitting down with local counsel and showing the relevant documents that you're talking about to a lawyer in the specific circumstance. I don't know if I've seen that before. Oftentimes I've seen contracts that ask the subcontractors to waive their lien rights before they've ever even started the job. And I have my own thoughts about whether or not those should be enforced.
Right.
But with respect to a lessee, I'm not sure I know the question. I'd find a local attorney and show them the specific
For that
document.
specific case. Okay. All right, wonderful. Thank you. Another question that came through, it says, on a commercial job, if it has been bonded, can I file the lien and still send the bond claim?
If the property is a private project and the property is privately owned, I suppose you could. Like typically, when I deal with projects that have been bonded, they're public work, and some governmental entity owns the land, and that's why you cannot file a lien.
Right.
Your recourse is to first use the bond claim, and then file suit against everybody, the owner, the general contractor, and the surety for the bond claim. But if it's a bonded private project, it seems like you could.
All right. Well, I do think that that's all the questions that have come through. If you do think of something else that wasn't addressed, please feel free to reach out to either myself or to Adam, and I'll be sure to answer any questions for you guys as quickly as I can. Adam, can you go to the next slide for me, please?
Sure.
All right, so here are some of SunRay's resources to help you stay organized, know your deadlines, and secure your lien rights. So go ahead and scan that QR code to access these incredible resources. Please remember, every state has its own unique lien laws, documents, and deadlines. So if you are working in a nearby state, whether it's Tennessee or Mississippi, wherever it happens to be, please go onto our website. You can put in that specific state and find out what documents and what deadlines would be necessary for that state. There's project information sheets that will kind of help you ask the right questions early on in your project. It's always easier to get information early on before there's any kind of a payment dispute. But if you have any questions, you can always reach out to us. All right, and then the next slide, please. All right, if you don't mind, give us a quick review on Google. We really do appreciate it. It takes only about a minute of your time, but it helps other contractors and suppliers like yourselves to hear about us. It also gives us better information as to what type of content you guys are looking for, or direct information or subject material. And then the next slide for me, please. And with that, that is all we have for you guys today. Thank you so much to everyone that attended. We hope to see you at our next webinar. Adam, again, you really are fantastic. So thank you so much for your time and all your information. I hope everyone has a beautiful and sunny day. Thanks, everyone.